Welcome to this week's Case of Interest. Kohberger, Newswatch 16, Stacey Lang. We have a lot to talk about today because a lot was made public over the course of this past week. Let's take a look at the Idaho Judicial Cases of Interest page, where we see the state of Idaho versus Brian Kohberger. A lot was added to this site over the past week, about 750 total pages. We're looking at it right now. All of these order to seal and redact. These are all applications for search warrants that investigators that are investigating the murder of those 4 University of Idaho students have filed since the time of the murders up until as most recently as just a couple of weeks ago. So this kind of gives us a bit of a roadmap, so to speak, of where the investigation has gone so far. And some of these documents have to do with the victims. Some of them have to do with Brian Kohberger. All of them are sealed. So we don't know exactly what was found when these search warrants were executed. We do know in some cases what investigators were looking for, and we know where they were looking. And you'll recognize a lot of these names here. eBay, Dropbox, Discover Bank. There's a lot of banks here. We're looking at banking information for Kohberger as well as all 4 of those victims. There's also, and I think maybe the most interesting thing that we can discover in these documents, they're searching some private companies as well as big retailers like Amazon and Walmart for purchases of K-bar knives, which we know from the knife sheath left at the crime scene on King Road in Moscow, Idaho, that is the murder weapon that is still being looked for as far as we know. We're going to get into that in just a little bit to help give us some legal insight as to what we're looking at here when we see all of these search warrant applications. We turn to some legal insight from right here in our area in Monroe County. Let's take a listen.
I'm joined by Brett Riegel, who is a partner in Arm Lawyers in Monroe County. Brett, thanks for joining us. We wanted to get your take on what's been the biggest drop of records from Idaho courts since Kohberger's arrest and extradition back to Idaho. While there's many, many documents, I think there's 750 pages. A lot of those pages say the same thing, that seal those documents. But does it provide a bit of a roadmap for what investigators seem to be looking into in this case?
Yes, I mean, it tells us where they're looking, not what they're finding. So we know that they are running down more and more and more social media and internet sources to find information. And of course, one of the main reasons that they're probably sealing those is because many of those types of things are an interaction, meaning it's not just Kohberger on a site looking for information. It may be a communication between him and someone else. And so they certainly don't want to breach the privacy of that other person, at least until they've had the opportunity to run that investigative lead down. Because quite frankly, when you're dealing with a multiple homicide that has this kind of national or international attention, you're going to run out every ground ball. If you are the investigative team, you're talking to everyone.
And we kind of get a bit of an idea of how they're doing that. And we see the bank records and social media accounts for all 4 victims and for Kohberger.
Yep.
When it comes to investigating these kinds of crimes now, how much are our digital lives, how much can they be a tool to investigators?
Oh, they're absolutely a fantastic tool for investigators. I think I made the comment in an earlier interview, and I know I've said it many times talking to people, that there's a common saying that the E in email is not for electronic, it's actually for evidence. And the meaning behind that is everything we do digitally leaves tracks. How long it's there, how thoroughly it's scrubbed, those types of things become a big issue. People frequently think, oh, well, I deleted that from my phone, it's gone. And it probably isn't. And in fact, one of the things that's frequently done in investigations is a phone dump to put together those bits and bytes of data that seem to have been broken apart by somebody who deleted it, but which are still actually there. And then the analysis can have them put back together so that they can see things that were deleted. In fact, not long ago, I had dealt with a case where the fact that certain messages had been deleted was one of the issues that the prosecution used at the time of trial, saying, well, we didn't recover these because they were in the message board of this individual. We discovered them because we ran the software that allowed the things that he had deleted to put it back together. And then we were able to tell what the communications were, and why would you delete something if you didn't have some reason to want to hide it.
And that can certainly be something that they're looking into when it comes to this case. In some of the documents, and I don't know if you noticed this in particular, but you can see what they might be looking for. Sure. In the search warrant for Amazon, Walmart, and then there were a couple of private retailers that, their name indicates that they sell knives, that they're looking for a purchase of that knife and knife sheath, which, as far as we know, has still not been recovered as the murder weapon. So with those search warrants in particular, what could that help prove from a prosecutorial standpoint? Well,
a number of things. If the investigators don't have the physical item that they're suggesting was used, they may want to enter something in as demonstrative evidence, which means that they're not offering this knife as the knife that was used, but rather based upon what the pathologist testifies to, etc. Pathologist might be able to say, well, I can tell you it was a knife approximately 8 inches in length with a Bowie knife style blade because of the way that the wound channel is, and we see marks on the skin from where the hilt of the knife created a bruise when it was used. So if they find something that matches that description in the order history, but then don't recover that item, that allows them to make the argument that, well, Kohberger had this in his possession. It's consistent with the damage done to the victims, and now he doesn't have it. We have no explanation for why he doesn't have it. What would you do if you committed a mass murder? You'd get rid of the evidence. So having it, being able to tie something very similar to the crime, and then not having it can be used as evidence of guilt. You also, you never know how those things might be used. If Kohberger testifies, for example, they might want to use a demonstrative knife, put it near him during cross-examination so that the jury gets a picture of Kohberger with the knife. Lots of things that it could be done with. The other thing, of course, is, and I think we talked a little bit about this once before, the premeditation angle. The state has to establish, when you're talking about a first-degree homicide, that there's a level of planning and that there was a set intention. And so showing that maybe there was shopping on a given day, and then some time, and then more shopping, and then some time, and then a purchase, that tends to establish that you were thinking about it over time. And particularly as you start to add the other aspects together. On the day that there is shopping, what do his text messages show? What do his other posts show? What is he researching on Google, on other areas? Does it end up linking up the idea that he was, rebuffed by somebody on day A and immediately starts looking for a knife and looking for things that would be supportive of the crime, and then a little time passes, and then there's another communication where he's receives an insulting something, and then we're back on the site looking for it again. It helps to give us that view into the mind of the person that they're putting on trial.
Yeah, you brought up an interesting point, because another huge unknown as far as the public is concerned is his connection to the victims.
Right.
Do
Exactly.
you think based off what we see from these search warrants that are sealed, that maybe not prosecutors, but the investigators aren't sure of what that connection might be?
Well, it could be, in my mind, it could be the following. It could be they're not sure what the connection is. They're running down all the ways they expect they can prove a connection, or they have an idea on what the connection is, and they don't want any surprises, anything that undercuts that, etc. Because a spot where I will always give incredible credit to the prosecution and the investigation side of a criminal case is my job, find the holes. Their job, think of everything that I can think of in terms of a hole and plug it before we get there.
Mm-hmm.
So when they're, and particularly a super high profile case of this nature, like I said, they're going to run everything out. So they've got probably a team of people talking about, well, what about this? Well, what about that? Well, would you say this? Well, would you say that? What about this angle? Because again, who knows what the defense is going to be? The one great thing that the Constitution really provides to a criminal defendant is the opportunity to use the weapon of surprise. They don't generally have to tell the prosecution what the defense is until it gets to trial, with some exceptions. Certain rules may require you to provide advance notice of a particular type of defense, like in Pennsylvania, if you're going to assert an alibi defense, or if you're going to insert a mental infirmity or insanity defense, you have to give notice of those ahead of time. But if you're asserting a defense of justification, for example, you don't have to give notice of that ahead of time. If you're asserting a defense that it was somebody else, and you're in fact going to try to establish who that other person was, you don't have to give notice of that in advance unless you are coupling it with an alibi. So if it's the idea of I was at home watching TV alone, well, that's not an alibi. There's nothing else that establishes that I was off doing that at the time of the crime. So I don't have to say I have a confession from the person who actually did this. I don't have to tell them that my investigation disclosed X, Y, or Z. And so the prosecution will always be trying to run those things out and get ahead of where the defense might go.
Mm-hmm. Since your job is to find holes, do you see any obvious holes in this investigation so far?
I really can't say that because we don't know what's in the affidavits of probable cause that support the warrants, or what's in the return on the warrant as far as what they got back when they served it and then it was complied with. Those could be spots where you could see something. And I would say, generally speaking, something of this magnitude, you're not going to see a glaring hole. You may see things that are very inconsistent with the theory, but not a hole, if that makes sense. In other words, there are always going to be things that don't make much sense in a case. The issue is it something that doesn't make sense, but it's there and you can see it? Or is it this doesn't make sense and there's a void of information?
That was Brett Riegel from ARM Lawyers in Stroudsburg giving us that insight. We might hear a little bit about the defense strategy for the next court hearing. That's the preliminary hearing for Brian Kohberger, scheduled for the end of June, but we might not hear much of their defense strategy, because when it comes to a preliminary hearing, the only burden is on the prosecutors, and they only have to prove that there is enough evidence not to convict, but in order to charge. That's all that they have to prove. So we probably won't hear much of the defense strategy until the case goes to trial, and who knows when that will be. And we might not hear much about what we're seeing in those search warrants during the preliminary hearing too. So we're going to have to keep a watch on the documents that are made public through the Idaho courts and see what they might tell us. And that's what this is for. So stay tuned for the next edition of Case of Interest Kohberger. Thanks for watching.